all over India where patent office are available. There you can go and submit the documents of the patent what you are going to file. Now, so it can be at the patent office situated in Delhi, like the states of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, that is from the northern side. They all can go and file their patent in the patent office of the Delhi. Next, in the Mumbai, there is another office which is situated in the Mumbai. The states of these, what we talked about, like states of Gujarat, Maharashtra, Madhya Pradesh, Goa, and union territories like Daman and Diu, Dadar and Nagar Haveli, Chhattisgarh, they should go. The inventors who are belonging to these particular states, they can visit this patent office in Mumbai for filing the patent. And the states of like ours, like AP and Telangana and Karnataka, Kerala, Pondicherry, the India, Tamil Nadu, Lakshadweep, these are the states you have to visit to the patent office of the Chennai, where we can go and file our patent. Next, in the Kolkata, the patent office situated in Kolkata. The rest of the India, like states like Orissa, Bihar, Bengal, West Bengal, Assam, Meghalaya, Andaman and Nicobar, they can go and visit this patent office in Kolkata. Next, what is the time or the lifespan of a patent? So from the date of filing our patent, your patent right is for a dual period of the lifespan of that particular patent is around 20 years from the date of you achieve your patent right. Okay, this is according to the Amendment Patent Act. The validity or the lifespan of that particular invention, that is the ownership, the inventor will that is the inventor will be the ownership for that particular invention for a period of 20 years. That is the whatever the patent you are receiving, you will be the first owner or the inventor of that. You will get that patent for a period of, that is, it is valid for a period of 20 years from the date of your grant of patent. And what is the government fee for filing a patent application? It is for example, it is like an individual, like be the person, a single individual who has done the invention and got with everything. So he can go and file with an around 1600 rupees. Now these has been changed. So accordingly, you need to go and file the patent application. For other individuals like an entrepreneur company, like an companies and all that, MSME, they should the amount is for 4,000, or for a public and a private limited companies, they can file the patent for their products. For filing the application is 8,000 rupees. And this is another important point. What are the things which are not patentable? Okay, we can't say that which is already available in the market and there were no inventors for that, I can go and file against that. So it is not like that. So an invention contrary to well-established natural laws. So for example, perpetual gravitational force, those are all the laws or the laws of thermodynamics. So they were all being found by the person, though they are not patent, but they were already invented and discovered by the people. So such are not being gone for patentable. And an invention contrary to the laws of the public health and morality, like drugs, food items, drinks, okay, those are all not patent. The mere discovery of any scientific principles or formulations of an abstract theories, or mere discovery of any living thing or not occurring in the nature. So the one which are already existing in the nature, the things or the discovery of those are not patentable. So for example, if I discover, suppose I'm talking about a taxonomist, he has discovered one plant. Okay, that plant already it is a living organism. They are there occurring in the nature. Okay, so though if you discover that a new plant in the nature, that can't be patented. Instead, if the use of that plant, for example, whatever the plant you have invented, if the plant is useful to the society, like if it is a medicinal plant or if it is a commercial plant, okay, so based on the utility of that plant, and what the product which is used from getting from that plant, what the product you are synthesized from the plant, and it is used by the society, which is useful to the society, that product or formulation or that product invention can be patentable, but not that living organism. I hope it is understood. Okay, so already which are existed in the nature cannot be patentable, but the invention what you carry on that particular product can be patentable. So that is a very important point to be remembered. Next, next in the IPRs, we are coming now to the trademark. Now, what is the trademark? So a trademark is a sign of the product what you have been invented, or the of the product or a good which is already available in the market. So that trademark can be a IP, that is intellectual property of that particular owner. Like for example, when we talk about just in the beginning I told you that Apple symbol on the iPhone, okay, that is a logo, okay, which is there on the iPhone. That is a trademark. Or the logo what we talk about, a Volkswagen or the Mercedes Benz. There are specific logos. By looking at the logo, you will identify what the product is. So that will call as a trademark. The logos on the product, okay, that will be a IP. Or the symbol, okay, the symbol like Nike, Nike, Nike symbol. Okay, so the Nike which is used for our like commercial, like your footwear or the accessories what we use like clothing and all those things. So the Nike symbol, that can be a trademark. Or the slogans which are written below it. The slogans like for example, McDonald's, okay, MC, that is the symbol. Okay, M. So I am loving N, the M symbol here. The slogan which is there below it, that can be a trademark. Okay, or we can take the shape or the Coca-Cola drink, the shape of that bottle. Okay, no other will, that is the company will get the patent or the IP, what the product, the shape of that bottle, the name of that, how it will, how design it will be written. That is a trademark by which that can be protected by the IPR. That is, if they get the patent right for that particular trademark, that should not be used by any other individual in the society. So those are the different types of trademarks which are protected by using our intellectual property rights. Next comes to the copyright. So what is a copyright? It is a legal term which is used to describe the rights of the creator over the literary or the artistic work. Suppose if we are writing a book, okay, that book is written based on your thoughts and based on your ideas and based on the knowledge what you want to deliver to the other people. Okay, all the literary work or the drawings or the paintings, you can make it as a form of a book or an art book or an artwork, whatever you synthesize. So those all will achieve the copyright. So you can have the legal right for that you are the ownership of that particular book what you have been authored. So they all comes under the copyright. So you can get the legal copyrights that you are the a true author of that particular thing what you have been done. So for example, like books. So many authors are there who will be writing the books. So all the authors can be go for the copyrights for getting the true ownership of that authored book. Or the music, the paintings, okay, the sculpture or the computer programs or the databases, all those things you can have the copyright of all these things by which you can protect your intellectual properties. Next, a design patent. So what is this? So this is the one which is a protection act, that is a IPR, where your unique designs can be protected. That is, that cannot be copied by some other else. that becomes a true owner of the design what you created. Like for example, jewelry, the design of a jewelry, like temple jewelry or the Nakshi work or the Pakshi work, what all the new designs what you get in the jewelry nowadays, all those are the new design. So the owner of who has created the design will get the design patent on that jewelry also. And also the automobiles. Okay, now you get different sports vehicles like sports cars, you will get sports bikes, you get, or the cycles. They all are the automobiles, whatever we are, there is a design given for that. Like a Maruti Suzuki owner, he has his own design of making that car. Okay, or the Tata company will have his own designing of the car is the common thing. Okay, where the design given to that will reflect the company there. Okay, that we call it as a design patent. So the company can go for the patent against the design, that the design cannot be copied by any other person in the market. And also regarding the script, the art of calligraphy writing or the script writing. So that all will comes under the design patenting. Next, regarding the plant variety protections. So due to the genetic engineering and biotechnology concepts, the farmers or the plant breeders, so generally we talk about the plant breeders, they are, this is a new thing what we have discovered, that they will have a right for protecting their plant variety, not to be made or not, nor it can be modified by something else. Like, so it is, we also calling it as a plant breeder's right. So it is a form of an intellectual property right which is granted to a new plant variety in relation to the act concerning the exploitation of the protected variety, or which require a prior authorization of the breeder. So the plant variety, whatever we are created, the plant variety which is discovered or newly synthesized, that plant variety will have the owner, the breeder will have the right of using that variety, and he will get the right of filing the case against other person who are exploiting or who are damaging that protected variety. So this is a plant variety protection. Next comes to the geographical indication. So this is also an IPR where the products are being identified based on a specific geographical area. Okay, so for example, we are identifying the product based on the area where it is been modified, where it is being used, or where it is been synthesized, or like that. For example, when I talk about the tea, okay, Darjeeling tea. So Darjeeling is the geographical area where that manufacturing, that is the growing of the tree plants and the industries which are preparing the tea powder is famous based on that geographical area. So that is one example. Or we can talk about here, this is what, this is a laddu, this is a Tirupati laddu. So this became famous on behalf of the Lord Balaji, the Tirupati or Lord Venkateshwara. So this Tirupati laddu is famous. Okay, we name it as the Tirupati laddu, not as a normal ordinary laddu. We call it as a Tirupati laddu. That is the Tirupati, the name, the geographical origin of that particular product is that can be protected by the IPRs. Next, or when it comes to the Kashmiri shawls, or when we come to our Telangana region like Kondapalli Bommalu, or the lac bangles, okay, whatever we are going to be synthesized, that prepared the product. Inka, Pochampalli saris, okay, the neem, the product neem, sari, for that, or Mysore silk sari, or the Mysore sandal powders, okay, that are the product which are reflecting the geographical area of its origin. So that has become the another IPR. Next, so what is the importance of this? So it provides a particular indication or a mark or a logo by the people who are using that product, and it will help the purchaser, that is the customer, when we go to different places, and it becomes a very easy for the purchaser or the user to identify the good of that particular geographical area. So geographical indication becomes a pure importance of how to identify a particular product wherever you go in the world, right? So what can be registered as an GI, that is geographical indication, how you can register as a trade, as a IPR for that. So any name, geographical or figurative representation, or any combination of conveying or suggesting that origin of that geography of that particular group can be registered under the IPR of the GI. Next. So who can apply for the registration of this GI is an association of producers of that particular organization or the authority who are established by or under any law representing the interest of the producers or concerned goods. And they can go for registration for this GI in the market. Next. So what are the particulars which are needed to file a GI application? So first thing is representation of geographical or this one. Next, the statement as to how this geographical indication mark serves to designate the good. Suppose I have created one product. So how that product is known by the people of that respective region. So that becomes the designation of the good. So that should be serving as a GI of the product what you synthesize. Or it is originating from any region of the country, irrespective of what the quality, reputation, and characteristics, which are essentially known to the geographical environment as the natural or the human factors. So all these should be kept in mind. Along with the application, the statement of these particulars of the producers and also the people who are using that should be attached for filing this IPR of the geographical indication mark. So the nominal fee for applying for GI registration to get that IPR, it is 5,000 rupees. And the person who has been authorized by the registered owner of the GI and whom have been incorporated in Part B, that can be used as a GI. And the lifetime for this is 10 years of the date from which the time the GI is registered, and it should be renewed from time to time. That is, if the time span is completed, then you can go for the renewal of using it, and that renewal time can be extended for a period of 10 years interval. So this is my presentation. So please, any queries? I'm just stop sharing. So any queries regarding this, my presentation on APRs and this?
Kavita? Hello, Kavita.
Yes, ma'am. Yes, Rajni, ma'am. Hello, ma'am. Okay, thank you, TIRUPATHI sir, for giving me this opportunity for delivering this lecture on IPR and patents. So I thank once again Principal Sir and Head Department of Botany, GDCW JAGTIAL, for accepting my request and selecting me as a resource person for today's webinar. Thank you very much.
Hello. Sir.
Rajini Madam.
Good afternoon, sir.
Good afternoon, madam. Please welcome and please speak few words.
Sir, good afternoon, Principal Sir. Good afternoon. Kavita, you expressed deliver very excellent and very easy way. Yes, sir. I think. Hello.
Yeah,
Thank you.
it's
Thank you, ma'am. Thank you very much.
it's a really appreciable moment because Madam has delivered an excellent and easily understood what about the current scenario, what are the intellectual property rights, and what about the importance of today's patents. How many patents our India has got, and how many patents is ready to file in the national or international movements. Anyway, my dear friends, if you have any doubt, please ask our respected Madam Gar.
My opinion. But 2 minutes. Okay, sir. Thank you. If there are no queries, then we'll wind the session.
Thank you very much, Madam. It's a very really appreciable moment, and you delivered an excellent lecture.
And thank you for your appreciation
A
certificate.
webinar on intellectual property rights and patents. In this regard, I would like to express my thanks to head of the institution, Dr. Yamsani Satyanarayana Sar Garu, Principal, Government Degree College for Women, JAGTIAL, and Head Department of Botany, Dr. G. Chandraya Sar Garu, Government Degree College for Women, JAGTIAL, and one of the prestigious institutions in Hyderabad, that is Rbvrr Women's College, Hyderabad, Principal, Dr. J. Achita Devi Madam Garu, and Head Botany, Dr. A. Rajini Madam Garu, and other department faculty members of Rbvrr Women's College, Hyderabad, and teaching and non-teaching faculty of both the institutions, and the important today's speaker, Dr.A.Kavita Madam Garu, wholeheartedly thanking you. Sunita Madam Garu, Sunita Madam Garu, please speak few words. Okay. Okay, with your permission, I will sum up today's event.
Yeah. Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you.